So the United States Court of Appeals for the Fifth Circuit just reversed a district court order rejecting a preliminary injunction against the ATF pistol brace rule and remanded the case to the district court for reconsideration.
So I initially did this video. I admittedly was kind of rushing because I had to travel and I only had a finite amount of time to put this video together. But I wanted to make this video as clear and as easy as possible to understand. After looking at the video, I realized that it probably wasn't as clear and concise as I may have wanted it to be. So for people who are just trying to get a quick understanding about what's going on with the pistol brace rule, this is me giving it to you right now. So you have the plaintiffs who brought suit against the ATF's pistol brace rule. They brought it to district court and the district court said, nah, we find in favor of the ATF, the pistol brace rule stands. So immediately the plaintiffs filed an appeal, brought it to the appellate court. And the appellate judges, there were 3 of them who looked at this case. 2 of them sided with the plaintiffs and basically said, no, we think there is merit to their argument as to why the ATF pistol brace rule didn't follow a certain procedure, which would mean that we can preliminarily injunct it. Now, they didn't rule that to be the case. What they said was, so because the district court didn't actually give a thorough analysis of how they came up with what they came up with to side with the ATF, we're going to throw it back to you guys using our analysis if you want or don't. Either way, we think there's some merit to this. So before we actually dive deeper into the analysis of whether or not they have merit, we want you guys to look at this case again and to determine whether or not they have merit. And the court gave them 60 days to do it. So for the next 60 days, nobody really has to worry about whether or not the ATF is going to come knocking on your door and taking your pistol braces. Now, after those 60 days, depending on what the district court rules, if they find in favor of the ATF, I'm pretty sure the plaintiffs are going to appeal and it'll go back to the appellate court and then it'll continue on from there. But in a perfect world, if things go great, the initial district court will find the same things that the appellate court found. And then we really won't have to worry about this shit. Well, we might still have to if the ATF decides to come back and try to do some other rules to make things work in their favor. But if the district court, after it's been kicked back to them, decides in our favor, then we're sitting pretty. Now, for those of you who want to get into the details of what the appellate court said as to why they figured that the plaintiffs had merit, continue watching this video and I'll break it down.
Spoken in plain English, and for those people who aren't too familiar with what's going on with this particular lawsuit against the pistol brace rule, I'm going to go down a quick history and then break it down for you in as easy a way as possible. So in 2021, the ATF put out a proposed rule that used a point system to determine if a brace made your gun a rifle or a braced pistol. The ATF accepted comments from the public about this proposed rule, and they were all negative. Then on January 31st, 2023, the ATF released a new final rule essentially saying any gun with a pistol brace is now considered a short-barreled rifle, and as a result, has to be registered under the NFA or you'll become a felon. In response to this, a lawsuit was filed by William T. Mock, Christopher Lewis, Firearms Policy Coalition Incorporated, Maxim Defense Industries. The plaintiffs, i.e. the people bringing the lawsuit, asked the court for a preliminary injunction which would stop the ATF from enforcing the new rule. The district court not only said no to the preliminary injunction, but it ruled that the ATF's new rule about pistol braces didn't violate the NFA, the First Amendment or the Second Amendment, and that it didn't fail the required APA procedural rules. You see, the APA governs government agency rulemaking. So if an agency puts out a rule, there are certain procedures they have to undergo for the rule to be valid. The plaintiffs immediately appealed this decision, which brings us to where we are now, the Fifth Circuit Court. There are 4 factors to determine if there can be a preliminary injunction. Number 1, a substantial likelihood of success on the merits. That's the important one. Number 2, a substantial threat of irreparable injury if the injunction is not issued. Number 3, that the threatened injury, if the injunction is denied, outweighs any harm that will result if the injunction is granted. And number 4, that the grant of an injunction will not disserve the public interest. Now, what this court did was simply look at the first factor and then sent the case back to the district court and said, you got 60 days to determine if the plaintiff meets the other 3 factors. You see, the ATF can't make laws. They can only make rules that interpret existing laws. The ATF is saying their final rule about braces only interprets existing laws about SBRs under the NFA. But this court said, nah. The final rule affects individual rights, speaks with the force of law, and significantly impacts private interest. As a result, it has the impact of a law, or as they call it, a legislative rule. And all legislative rules must follow the APA's procedural requirements for notice and comment, including providing the public with a meaningful opportunity to comment on the proposed rule. The final rule the agency adopts must be a logical outgrowth of the rule proposed. If the logical outgrowth requirement is not satisfied, a court must set aside the agency action found to be without observance of procedure required by law. The court found that because the first proposed rule allowed an individual to analyze his own weapon and gave each individual an objective basis to disagree with the ATF's determination, the final rule vests ATF with complete discretion to use a subjective balancing test to weigh 6 opaque factors on an invisible scale. The final rule is not a logical outgrowth of the initial rule proposed, and because of this, this final rule violates the APA procedural requirement that I mentioned before, and thus the plaintiffs meet the first factor for a preliminary injunction. Long story short, the court is saying, based on our quick but not so quick analysis, you might want to take another look at this case and rethink your initial ruling. And in the meantime, we'll give you a 60-day injunction, but we'd really like it if you ruled on this within 60 days. Now, keep in mind, there were 3 judges involved in this decision, but only 2 of them ruled in favor of kicking it back to the district court because they felt the plaintiffs met the requirements for a preliminary injunction. The judge who sided with the ATF was appointed by, wait for it, President Obama. Again, demonstrating how anti-gun the left is. The other 2 judges were appointed by Ronald Reagan and Donald Trump. This goes to show how you vote has a direct consequence to your 2A rights. If Hillary had beat Trump, I'm certain this would have been a different ruling. Now we wait and see what the district court says. Speaking of Hillary Clinton and the rest of her anti-gun cronies, you see, a lot of these anti-gun politicians, the one big thing that they want to do is ban AR-15s. Now, you and I know them as semi-automatic rifles. They like to call them assault weapons to scare people and get them to vote to get them banned. But you and I understand that these are incredibly important to not only protect our lives and our family, but also to protect our freedom in this country from a possible tyrannical government. This is why I came out with the Keep America Tactical collection and design. So as you can see here, I have my Keep Texas Tactical. And the beautiful thing about this is these come in all 50 states. So whatever state you live in, there is a Keep America Tactical version of it at shop.mrcolion.com. And I know there's some of you who live in states that are anti-AR-15s and you can't even own an AR-15, but that doesn't mean you can't utilize your hat or your shirt to advocate for the reinstatement of AR-15s in your state. And also, I'm going to be doing a giveaway in about the next day or 2. And I'm only going to do it for my YouTube members. Now, for you who don't know what YouTube membership is basically another way for you to support the channel and what we do here for the 2A. It comes with 3 groups. There is the Pew Pew Life, there is the Militia, and then there's the Amosexuals. Now, each of those groups has their own specific perks and benefits that come with it. But on top of that, I like to do these unofficial giveaways for the members in those particular groups. So if you want to learn more about YouTube membership, I'm going to put a link in the description section so that you can go ahead and check that out. And don't forget to like, share, and subscribe to the channel. And to make sure you get all of the notifications letting you know I've released a video, click the bell symbol. There's a drop-down menu, click all, and you're good to go. Guns aren't political. That's why I need your help getting this message to spread on YouTube by clicking the thumbs up button, leaving a comment to let me know what you think of the video, then subscribing to the channel. But most importantly, click that bell symbol. For products featured in this video, click the links in the description.